And his wife is a secretary with the government.
Isaac, can you hear me?
Yes, Mr. Chair, I can.
I think I started recording by mistake. I was clearing the screen here in the hearing room. So I don't know if you can discontinue the recording and then start it at 9:30? Or is it on us?
Well, I can do that. The YouTube stream, I can't, since it's already started streaming, so I could post the link. I can't really delete these couple of minutes, but when I post the YouTube videos, the link on the website, I post them with the time code, so it starts right at 9:30 if you click at the link. But it will always be possible for people to come back to this moment and watch this if they want. But I do post the link in a way where they skip all of this and go straight to 9:30.
Okay. Thanks, Isaac.
No problem.
Good morning, everyone. It's 9:30 on the dot. I'm Joe Maestas, Chairman of the Public Regulation Commission. I want to welcome everyone to our regular weekly meeting of the Public Regulation Commission. I'd like to call this meeting to order. Judy, will you be handling the roll call and the roll call vote, or is that Russell?
Yes, I will be handling the meeting today for the Office of General Counsel, and I will take the roll call. Chairman Maestas,
Here.
Commissioner Byrd,
Yeah, I'm not here.
Commissioner Fishman,
Commissioner Byrd lied.
Commissioner Vicente Aguilar, Commissioner Hall,
I'm here.
and Chairman Maestas, we have a quorum of 4 commissioners.
All right, for those of you here in the main hearing room, please rise for the Pledge of Allegiance and the State Pledge. Jeff, do you mind leading us, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico and the Zia symbol of perfect friendship among united cultures.
Please remain standing if you don't mind. I'd like us to have a moment of silence for all of those individuals that have been affected by our wildfires, people that have been displaced, living in shelters, people who have lost their belongings. So we're going to have a moment of silence. And before we do, I'd like to invite any other commissioners to make any comments or about the wildfires. Commissioners, anyone wish to make any comments?
Mr. Chair, I join in you in wanting to do this because it's just a frightful disaster that's affecting so many people in our state. And my heart goes out to them.
Thank you, Vice Chair Hall.
Mr. Chairman.
Commissioner Byrd.
Special recognition or note, we have staff members that are being directly impacted by this, either themselves or their families. Of course, I've got friends and stuff in there that have lost buildings. They think their home's okay, but there's a lot of houses lost of people I do know. So anyway, thank you for lifting up a prayer for these folks, and let's hope that rain comes soon, because that's really our only way to defeat it.
Yeah, thank you, Commissioner. Anyone else? All right, just a moment of silence, please. All right, thank you all. Please take your seats. Thank you, Commissioner Byrd, for leading us in the pledges. All right, members of the commission, you have the agenda before you. There are 2 items that I recommend we remove. This is per recommendation from General Counsel. It is 1 item under consent. It is
Mr. Chairman, I can chime in if you like. Yeah, that's the one, 20-00241-UT. I'll bring that back next week. And there's one on regular agenda as well, the regular agenda, which is 21-00112 UT. I'll bring that back next week with additional motions to be considered.
okay. So we have 2 items that are recommended to be removed. Are there any other suggested changes to the agenda? Okay, hearing none, do I hear a motion to approve the agenda as amended?
So moved.
Okay, we have a motion by Vice Chair Hall. Do I hear a second?
Second.
Second by Commissioner Byrd. Any discussion on the motion? Okay, hearing none, roll call vote. Judy?
Yes. Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd,
Aye.
Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar. I'm not sure if she joined the meeting.
I'm here, Judy. I vote
Oh.
aye.
The motion to approve the agenda as amended passes 5-0.
Thank you, Judy. Let's move on to introduction of special guests. Isaac has informed me that we don't have any special guests or public comment. Is that still the case, Isaac?
That is correct, Mr. Chair. To my knowledge, there are no special guests and no one has signed up for public comment.
Okay, let's go ahead and move on to consideration and approval of prior meeting minutes. Members of the commission, you have the minutes for the April 20th, 2022 open meeting and the same for the April 27th, 2022 open meetings. Do I hear a motion to adopt the minutes for both of those open meetings?
So moved.
Okay, we have a motion on the floor by Vice Chair Hall. Do I hear a second?
Second.
Second by Commissioner Fishman. Any discussion on the motion? All right, hearing none. Judy, roll call vote, please.
Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman.
Aye.
The motion passes 5-0.
Thank you, Judy. Let's go ahead and move on to consent action items. We had one item removed, so we have a consent agenda as amended. Do I hear a motion to approve?
So moved.
Okay, we have a motion by Vice Chair Hall. Do I hear a second?
Second.
Second by Commissioner Byrd. Before we entertain any discussion, Judy or Russell, who will be reading the?
I can read the consent action agenda items. There is a transportation matter, case number 22-00064 TREN, in the matter of the investigation of Calm Transportation LLC. Utility matter, case number 19-00106 UT, in the matter of applications for 2020 broadband program support from the State Rural Universal Service Fund as per 17.11.10.31 NMAC, potential order regarding Windstream's request for initial disbursement for Cuba project. And lastly, we have case number 22-00066 UT in the matter of the application of New Mexico Gas Company, Inc. for a variance from 17.10.640 NMAC for its April 2022 gas cost factor statement. Potential order regarding application for variance. Those are all the items on the consent agenda after removal of the previously discussed item.
Okay, thank you, Judy. So we have a motion and a second on the floor to approve the consent agenda as amended. Any further discussion on the motion? All right, hearing none. Judy, roll call vote, please.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd,
Aye.
Commissioner Maestas.
Aye.
The consent agenda items pass 5-0.
Thank you, Judy. Let's move on to regular action items. We have none. Under transportation, the first one under utility matters is in the case 18-214-UT in the matter of an order to show cause as to why Rosa Joint Ventures, a New Mexico partnership, should not be found in violation of the Public Utility Act and commission rules, and we will be acting on a potential order regarding failure to close upon transfer agreement. Russell Fisk, do you want to tee this up?
Yes, Mr. Chairman, Commissioners. So as you will recall, this has been an ongoing saga of delay. Let me start just a brief recap of how this started. This case began, Rosa Joint Ventures is a small water utility that operates up north near the border of Colorado. And it has never had a CCN. It's never come to the commission to be regulated. So there was an order to show cause issued as to why it should not be found in violation of the Public Utility Act and commission rules for that reason. It was sent to Ashley Shanauer as a hearing examiner. And as is typical in cases like this, where a water utility is operating unregulated, the hearing examiner was open to, and the commission was open to the possibility of avoiding penalties for these numerous violations resulting from the fact that they've never been regulated, to allow for a transfer of the water utility from Rosa Joint Ventures to a mutual domestic to be formed. And during the course of that, I want to say it was before Ashley for about 2.5 or 3 years, there was a substantial amount of delay by the parties, both sides. And San Brito, which was eventually the mutual domestic that was formed, took a long time to form. I mean, these are difficult situations, but there was completely unreasonable delay there. And Rosa Joint Ventures as well didn't take actions as quickly as they should. So that was the case before Ashley Shanauer went on for a very long time, much longer than it should. So there was already a history of delay among these parties. Then it came to the commission for a approval of a transfer agreement and stipulation that it was recommended by Ashley Shanauer. The commission approved that. I believe it was June of 2021. Then there was an estimated 60 days until closing. Well, as you know, this transfer still has not closed. And the commission imposed fines, first in the amount for the initial period in the amount of $100 per business day. And then now they're accruing at the fines are accruing at the rate of $300 per business day only against Rosa Joint Venture, not against San Brito, even though San Brito is clearly responsible for part of the delay. The reason for that is that San Brito as a mutual domestic is not subject to commission jurisdiction. So, but those penalties continue to accrue. And of course, that was, as you will recall, for the reason that after the transfer agreement was approved by the commission, apparently no actions were taken by our Rosa Joint Venture or San Brito to accomplish what needed to be accomplished. And specifically, there were 2 administrative processes that needed to be completed before the transfer could take place. One was with the Office of the State Engineer to identify and effectuate a transfer of water rights from RJV to Rosa Joint Ventures to San Brito. And the other was with the San Juan County, which needed to issue a new subdivision map for the area before the transfer could happen. And as you will recall, the 2 parties had not even begun that process. They only began it when the commission started to impose penalties. So, so there's clearly delay among that has occurred as a fault of these parties. As I said, though, in my memo, I'm not sure at this point how much of the delay that is ongoing is due to the parties. It could be a substantial part, it could be all of it, or it could be, relatively little of it, because the processes before the Office of the State Engineer and the county, seem to, there could be delay on their part, or a backlog, as many agencies are experiencing and have experienced, and that is claimed by the parties. I just don't know at this point what the share of blame is, but the proposed order that I have prepared would just keep the fines in place in terms of they continue to accrue, because, and there's the reason for that is, as you will recall, last week this was on the agenda, and then there was something filed at the last minute, which is also very typical for these two parties, to file something only when they see that something is on the commission's agenda, for an approval, or for really, they didn't ask for approval. They just filed something that said that the transfer has been accomplished. You may recall that once before the parties tried to do this in terms of saying, well, we've done as much in the transfer as we can without having these agency processes completed. The Office of State Engineer in the county, they executed a leasehold instead of a fee simple interest, because RGV couldn't convey a fee simple interest to San Benito without the new subdivision map, and et cetera, et cetera. This is a similar type of thing. What was done last week was in the filing was to notify and to provide evidence that quitclaim deeds were executed and recorded with the county for the transfer of the relevant property to serve the water utility from Rosa Joint Venture to San Benito. And San Benito said they're willing to accept. They believe that these quitclaim deeds will be sufficient, and they're willing to accept them in lieu of what would be, a more specific deed that would describe the particular interest in property that is being conveyed. And they believe this shows that they're taking every step they can in light of the fact that they're still waiting for these two, with the county and the Office of State Engineer, to finish their processes. I don't think this helps in any way. This doesn't accomplish the transfer in any manner. It doesn't move the ball forward. In fact, I don't think quitclaim deeds accomplish what the parties seem to think they do. I practiced a little bit in the world of real property, and of course I've been educated in that area. And quitclaim deeds do not fix this problem. Quitclaim deeds are used when an entity that's transferring, or a person or entity that's transferring property, doesn't know exactly what type of interest and the extent of the interest that person owns. That's not really the problem here. The problem here is that because there's a new subdivision map needed from the county, it's not that RGV doesn't know what type of interest it has. It's that the legal description, the current legal description of the property, which is the one that's on the quitclaim deed, is not one that I think the county would recognize, or it wouldn't be proper, because the map is the map that's currently recorded is outdated and doesn't reflect the actual situation. So doing a quitclaim deed does not fix that, because what needs to be fixed is the legal description that's attached to the quitclaim deed of what the land is. The new subdivision map will describe it differently. It will subdivide the land into parcels, I think, is how that's done. So that's one reason why this order would simply say that that the fines remain in place, that this is not a transfer. The fines will continue to accrue until there's an actual transfer as per the transfer agreement, because this doesn't accomplish anything. And so let's see. I do, like I said, at this point, I have what I'd like to do is gather some information through staff, because there are some things that are claimed in this filing. For instance, with regard to the New Mexico Environment Department, NMED, which also regulates water utilities. They regulate their quality of water. And NMED also regulates mutual domestics and helps them get set up. And NMED has been involved in this matter, but NMED also is the steward of money that's been money that's been appropriated by the legislature, and I believe they also have other types of support they can provide to a mutual domestic to help hire a certified operator and all of that. But none of that can be done, as the commission knows, none of that can be done until there is an effective transfer to the mutual domestic, because this would be government money that would be for helping repair this system, which is in poor repair. And as per the anti-donation clause of the New Mexico Constitution, it can't go to a private entity like RJV. So it's critical that this matter, that this transfer close, so that the money can be released and the repairs can begin. It's a bit odd to me, some of the things that are said in the filing, because there are references to Sambrito's intention to work with the legislature, or the legislative delegation that would apply to that area, and the NMED about receiving funds, but they don't describe how in lieu of a true transfer, of a valid transfer, or maybe they believe this is a valid transfer, how those funds can't be released. That's my understanding. I would like to, after this week, issue a single signature order to staff to get some more information about where NMED stands on this. If there is the possibility that funds could be released based on this, I highly, highly doubt it. But and to look into really that question and a couple of others. But at this point, I can comfortably recommend to the commission that it issue an order that says, nothing has changed. Just like when the parties tried to fix this through a transfer that, that wasn't truly final, by doing a leasehold, doing these quitclaim deeds isn't going to do it either. These processes at the Office of the State Engineer and the count and San Juan County have to be completed. In fact, the parties themselves have said that all along. The only thing, as I said, that I would also like to ask of staff to look into is whether an appreciable part of the delay at this point is due to the Office of State Engineer or the county, as opposed to the parties. The parties may be acting diligently now. I'm not sure. But again, the commission can go ahead and issue an order today that says what you filed last week, parties, is not effective. It doesn't change anything. So with that, I can take any questions.
Thank you, Russell. Any questions for Russell?
Yes.
Commissioner Fishman, go ahead.
Yeah. So Russell, we spoke a little about this last week, and correct me if I'm wrong, and staff can probably update us on this. It's likely, and I heard, and I recall hearing when I first came on the commission, that there are a number of other water companies, small water companies, that may not be in compliance in terms of having gotten the CCN. To your knowledge, is that the case?
Yes, it's likely that there are, because this one we discovered through a complaint. And it seems that many water utilities are, especially because most of these water utilities arise as from the development of a subdivision or development of a housing development. For some reason, they're always regulated by the Mexico Environment Department. For clean water, they're always made aware of that, or the NMED is made aware. But it's often happened that the commission is not aware of a new water utility, and the water utility is not aware that it needs to be regulated by the commission. So there almost certainly are some more. There was actually a project done I want to say 2 or 3 years ago, by staff to identify such water utilities. And there was, I would like to, I'd like to include that in the bench request to staff because it's a good point. I don't recall, but they didn't identify very many. I think they actually looked at the records of the New Mexico Environment Department and saw which water utilities, which were not mutual domestics, because those would not be regulated by us, but ones that were private companies.
So my recollection when I spoke with staff people about it was that it was something like 8 or 9. I don't know
Yes,
the
that's what I
exact
recall.
number, but it was less than 10. But,
Yes.
you know, in talking with you, I mean, what you were pointing out to me was that, you know, most of these are small, rural, if you will, water companies that, you know, might have a couple hundred customers. And just real quickly, is that a correct characterization?
I believe so. I actually haven't seen the list of 8 or 9. I do recall that it was 8 or 9, so I was glad that we have the same number in mind. But I assume they're relatively small. There could be, you know, a larger one that also was unaware that it needed to be regulated by us. But I think they are relatively small, because the ones I've had to deal with, I've had a couple other cases of water utilities, for instance. Sometimes upon the death of the developer or the owner of the water system that didn't know that it needed to be regulated, when the probate comes along, the attorney, an attorney becomes involved and looks at it and says, "Oh, gee, you should have been regulated all along by the PRC, so you better get that going. Either get regulated yourself or transfer." So that's been a way. I think a couple of cases come before me, and yes, they're usually very small, very rural water utilities.
Well, so here's my thought: is that because of the nature of them, and I think we're seeing that in this case, is that the parties have very little expertise and very few resources to address some of the regulatory issues that come into play. Would that be a correct characterization?
Yes.
Then, you know, it makes me wonder, and I'd had a short conversation with Commissioner Hall about this as well, is that maybe it's appropriate for us to find a way to help these folks out. And, you know, it could be declaring an amnesty and, you know, having people come in and coming up with some kind of way to offer them some expertise or support so that they can get into compliance. And it might be you know, a legislative thing. I don't think it'd be a ton of money, but it would kind of it would make it easy for everybody to come forward and us clean up these regulatory issues with them. And I'm wondering if you think that would make any sense.
Commissioner Fisher, yes, I do think it would make sense. And to be honest, I've been curious as to, you know, I remember when the presentation was made by staff about those 8 or 9 utilities. I don't recall what if any action was taken, and so it certainly makes sense to take such action. And, you know, that you described, you know, as an amnesty, what you described as an amnesty is how we handle these matters when they appear to us. So it does make sense to reach out to the ones that we are aware of through that study or work by staff. I mean, this is a case in point. You know, what the commission approved in its order was a stipulation that was recommended by the hearing examiner that would forgive all of the regulatory violations for the past, and based on the fact that the parties did work together to form a mutual domestic. And, you know, once the transfer is effective, then there is money ready. And I have to say that's one thing that in my experience, the government, the state government of New Mexico, the legislature, the DFA, and are very good about is getting that money ready. Because the other case I had, where there was, you know, an issue of forming a mutual domestic, and it is difficult. It's something new for the people involved. was of course the famous AV water case. And that was a case again where the state money was ready. So I think the state government does a very good job of getting it ready. And you need the mutual domestic and had to be fully formed, and you need the transfer to happen. And in this most recent filing, the mutual domestic does describe that they've made a lot of progress in understanding billing and metering, which are the things that the mutual domestic board members, that's what they handle, because they'll hire a certified operator. NMED will even give them a grant for that in terms of operating the system itself. And, they'll be with the appropriation for the legislature. They compare an engineering firm, which they've already, contracted with. So that's the way we do handle these on an individual basis. But I think you're right. I don't know if there was any kind of a reaching out to that list of 8 or 9.
So, and I'm going to give Commissioner Byrd some credit for framing my thinking on this, is that, a lot of times we want to regulate through punishment, fines and such. And sometimes you just run into a case where, maybe the best thing here is to just basically offer support to help folks get into compliance. And I'm thinking that I think it'd be worthwhile to maybe have staff put together some ideas about how we can identify the folks that are not in compliance, what kind of support they might need to get into compliance, and then figure out whether legislatively or in another way we can get some funds in place that those companies can retain the expertise to get into compliance, and then we can move forward. And then instead of, hopefully in the future, instead of running into emergencies that come up, that people will be more willing to work with the regulatory community to help resolve problems before they become a crisis.
Yes, I think that makes a lot of sense.
And I guess my sense is that if we came up with a proposal, I find it hard to believe we'd have a lot of resistance in the legislature to doing that kind of thing. So anyway, I'm going to just throw that on the table for other commissioners to comment on. And that's it for me for now.
And Commissioner Fisher, just to add one thing, can I say one point? One thing that people have pointed out at this agency is that such legislation should include something that informs, developers, subdivision developers, housing developers of the regulatory requirements, because it doesn't seem that they're aware of them. So that seems to be a problem. We're not aware of them, their development, and they're not aware of us. So legislation might help there. Okay. I'm sorry, Commissioner Hall, I'm sorry.
Oh, that's okay, Russell, you need to respond. Mr. Chair, if I may.
Yes, Vice Chair Hall.
This issue has been talked about a lot in the past, about the fact that a lot of rural water utilities just don't have the financial or wherewithal or the expertise to really deal with their problems going forward, even though they were set up by a developer and worked well, ran well for some period of time. Eventually, when the developer retires or ages out or dies, oftentimes the next owner who comes along has problems maintaining the infrastructure due to all sorts of things, people moving away, lack of funds. So I think it's definitely a chronic problem in New Mexico. And I believe it happens, certainly in other parts of the United States too. And my limited knowledge on the national scale is that there are, larger financial institutions who look around for opportunities in these water companies to purchase them and revitalize them and help them get back on their feet. But barring anything like that happening in New Mexico, which I'm not aware of anything like that happening. In fact, really to the contrary, these companies just seem to languish like in a problematic state, like Rosa Joint mentioned now. I think what Commissioner Fishman is talking about is something we really ought to do. We need to reach out to the legislature and see what sort of solutions can be found. I think it's a great idea to look for funds to help these utilities straighten out their problems, but I'm not sure we should limit it to just looking for funds. I've thought sometimes that might be useful to have some sort of state office or state authority that could take, I don't know whether it would be ownership or could be empowered to take certain actions depending on the instance to reform the companies, and if nothing else, place them under receivership or something. That has happened in the past as well. So I think we should, I don't know if it's too much of a burden to put on staff, but it would be, I think what Mr. Fishman was suggesting staff should do is just to identify the companies that could use help is a good idea. But I think we should maybe look into what sort of legal structures might exist elsewhere in other states, or what might be useful for us to conjure up that could provide a little bit more governmental structure on what to do with the problem of these failing water companies. Because I don't think the problem is going to go away. I think it's going to pop up more and more as time goes by and infrastructure fails. And having just heard what Russell said now, which is that current developers don't seem to be aware of the problems, is kind of a little red flag to me too. If it's kind of hard to imagine that they, with the knowledge of these companies presently having trouble functioning, the older companies having trouble functioning, I'm astonished to think that modern developers in this day and age don't understand that that's a problem. But even so, I guess they can't protect against everything that happens in the future. So I guess what I'm getting at in this lengthy way is that I think we should maybe, if not start a notice of inquiry, have some sort of tasking of somebody in staff to look at the possible legal options that there are for the legislature to pursue in addition to funding.
Thank you, Vice Chair Hall.
Yeah.
Any other commissioners have any comments or questions on this case?
Mr. Chair.
Yes, Commissioner Byrd.
Thank you, Mr. Chair. Thank you, Mr. Fisk. Ms. Amir and I were doing a little bit of research back in February. We may actually have some regulatory authority over mutual domestics. And I can give you a partial quote of citation here. I took a picture of it and sent it to Ms. Amir. Anyway, the citation is 3-29-17.4 AN, and the language, and it's just a part of the language, but it says an association shall file within the time prescribed by the Sanitary Projects Act on forms prescribed and furnished by the Public Regulation Commission to the association not less than 30 days prior to the date and report is due. An annual report setting forth the name of the association, the address of the registered office of the association, a brief statement, and that's where it cuts off. But there's more information that's supposed to be submitted by mutual domestics to the commission. It would seem that if they're supposed to be reporting, then therefore we also have some regulatory authority over them. You might want to look into that citation. Ms. Amir, we were doing this on February 22nd I think we exchanged some emails in there, and this document was sent back and forth between us. So anyway, if you guys could look into that, we may actually have some authority over mutual domestics.
What's
That's
that
it,
site
Mr. Chair.
again? Excuse me, Mr.
What was
Sheriff.
that, Vice
What's
Chair Hall?
this? What, I just wondered what the site was again, that statutory site or?
Yeah, so
rural?
what I have is 3-29-17.4.AN, and it cuts off at that point. But we know it's the,
Oh,
well, I read file prescribed Sanitary Projects Act that gives us at least reporting requirement authority from mutual domestics.
uh-huh, thank you.
Thank you, Commissioner. I will definitely look into that. It's interesting that the statutory provision may provide some limited authority. My basis for excluding Sambrito from any fines, there is a New Mexico Supreme Court case that in which there was similarly a transfer of a water utility from a regulated by the PRC public water utility to a mutual domestic, and what is allowed in such transfer is that the commission may condition approval of the transfer, because the commission must approve the transfer, upon the mutual domestic promising to do certain things, but the commission has no way of enforcing it. Those promises by the mutual domestic, things that can be, the commission can compel to be done, immediately as conditions precedent. The mutual domestic will usually agree to do because the mutual domestic, like the water utility, wants the transfer to go through. So we have some power usually in that sense. But this case, I think it was called El Vedito. I think it was the name of the water company. It was the Supreme Court made clear that the commission can't enforce any conditions or any requirements or penalties on the mutual domestic after at all. That the mutual domestic's participation in the transfer case before the commission is voluntary, and they may agree voluntarily to certain things, but that the commission has no power then to enforce anything against the mutual domestic, because they are generally solely regulated by the Environment Department. But I will look into this statutory section because I was not aware of that.
Mr. Chair.
Yes, Commissioner Fishman, and then Commissioner Byrd. Okay.
So, as I'm listening to this, it seems to me whatever ideas we develop, and there's lots of ways to go about this, but if we want to pursue a legislative route, which I think to provide funds we may have to do, quite frankly, and I don't think it's a ton of money that it takes to do this, but it should be a partnership in terms of putting together some ideas between the PRC and the Environmental Department. And Russell, does that make sense to you?
Yes.
And is there anyone from staff who's listening in who handles the water cases that would like to make some comments and make sure we're not headed off, or I'm not headed off in some crazy direction here?
And Commissioner Fishman, it's okay it will be okay for staff to comment on your proposal going forward for a broader approach to these matters in general. But as staff is a party to this particular case, they shouldn't discuss this case.
Okay.
Commissioner Fishman? Anything else, Commissioner Fishman?
No, that's it.
Okay, thank you. Commissioner Byrd.
Thank you, Mr. Chair. And just in response to your answer, Mr. Fisk, you said that the Supreme Court said it's voluntary. If this act was created since that decision, that would change that. And if this act was not cited in that Supreme Court case, therefore they had no knowledge that it existed, would that not also be a reason to take it back? Because it says they shall file, and that's not voluntary.
Commissioner Bird, that's very interesting. I will say the Sanitary Projects Act did pre-exist this particular decision, because the Sanitary Projects Act is actually the act that established mutual domestic water consumers associations as an entity. This may, I'll look at the statute. It may just be a particular reporting requirement that has been that we would have enforcement authority over. But generally, in New Mexico, the Environment Department has exclusive regulatory authority over mutual domestics. And what I was saying is that, with regard to mutual domestics do appear, just in this case, do appear as parties often in the transfer cases, because they want to, help reassure the commission about, what the agreement is and how they will execute it, because they want it to happen. But ongoing responsibilities, we don't really have any authority over those under the Sanitary Projects Act, as far as I'm aware. But this report is something I wasn't aware of. But this report may be an isolated case of limited authority. But I'll look into that.
Thank you, Russell. Russell, do you have the scope of the legislative appropriation that we've been discussing? Do you have the scope of that?
That I do not have, Mr. Chairman. That's a very good question. That's something I also would like to ask staff to provide some information on, because staff usually, staff is often has been very involved in this case, and is often very involved in water case. We have very experienced staff with regard to water utilities, in helping them, receive the money they need, mutual domestics to receive the money needs to receive, to make sure that everything is ready. And I'm just not aware of what the appropriation is. I want to say, just based on my memory, but my memory is not great, that there was a $30,000 appropriation by the legislature. I want to say either last year or the year before. I'm not sure if that's still available even. So, and I'm not very familiar with budgeting issues, and I didn't really look into this one, but I will ask staff about that as well in a bench request.
So I think that's important, because we all know, a clock ticks on capital outlay, and I think it's 3 years, and then it reverts back to the general fund unless the recipient reauthorizes it for another purpose. What I'm getting at is I think we've been discussing this case only focusing on the conditions to the transaction, to the change of ownership. And all the while I'm thinking about the status of the water system. What is NMED doing? They're not in the business of being an interim operator, but they do regulate them, and they have not allowed that system to be operated right now under these circumstances. And so I'm concerned about the water system itself. What's the timeline? How many folks are being impacted by this delay? There was some information, I think, in the memo about a broken water line that interrupted service completely. We all know that you need to have adequate water pressure for fire suppression. I feel like I'm blind in terms of what's going on the water system side, and we're focusing solely on our own timeline and all the compliance milestones that we have been expecting as a condition to transfer of ownership. And so what I'm saying is I agree with some of the comments that have been made, that we need more information in general, and we do need to assist these small water systems. But the case that we're discussing is a specific case, and this has been pending since 2018, and I think we need to move forward to resolve this situation. But I think we need to be sensitive again to what's going on the water system side. And also, I think we've talked about this in the past. We have sister agencies where we have a nexus on certain actions, whether it's energy and minerals or NMED. I think we need to start moving forward with some kind of an MOU with these sister agencies. That way it's a bit more seamless when we have issues like this that involve our sister agencies, instead of kind of kicking the can down the road, getting more information, getting an update from NMED. So, I mean, I'm fine with the order, but I don't think it really serves any purpose. We're just allowing the fines to continue and the clock to tick. But I, for one, want to know more about what's going on the water system side and the appropriations. I mean, we're trying to accommodate this transfer of ownership to allow the appropriation funds to flow. I don't even know what the scope is of the appropriation, whether it's still available or if it could be reverted back to the general fund, since this has been pending for so long. I'm even wondering how the appropriation could have been made under these circumstances. So that's kind of where I stand. I realize it's not very action oriented, but I do think to make a responsible decision, I think we need more information on the system itself. And I think hearing from NMED in terms of how they feel about this, I think would be of great value to us before we make a final decision. I haven't heard from Commissioner Vicente Aguilar. Commissioner Vicente Aguilar, any comments on this case and water systems in general?
Yes, thank you, Mr. Chairman. Mr. Fisk, we wanted to get more information from the staff because they probably have it since this case was open since 2018. And why are you reluctant or you're denying the staff to speak on the case?
Commissioner Vicente Aguilar, only because staff is a party to the case, and this is not a hearing, so it would be an ex parte communication. But I can ask all those questions through a bench request that's filed in the record, to which Rosa Joint Venture would have a chance to respond. That's the only reason is that it would raise an ex parte issue, and because they'd be making a communication without any notice to the other side, to the commission about the case here at an open meeting. So, but a bench request will accomplish that. And probably a bench request will be the best way to ask these questions, in the sense that there'll be detailed answers, technical answers.
Thank you, Mr. Fisk. I think the recommendation to go to the legislature is good, but it's a long road. Lately, the legislatures, they've been looking the other way with any type of inquiry that we have from our agency. That's number one. Number two, working with the other state agencies, I see very small movement as far as working together and creating partnership. It should have been robust right from the beginning, but clearly it tells me they're not interested. So that's my opinion about the two recommendations that were made. But I think Commissioner Byrd indicated that, yes, we have a certain amount of regulatory authority. I just want to use another example. There was also a water transfer, mutual domestic water case. I believe it's AV Water in Farmington area, and that was resolved. And the way that it was resolved was that the commission ordered staff to organize a public hearing, and I would go in that. I would consider that path because, that's one case where it was resolved, and And I don't know, Mr. Fitz, you might look into that. I'm willing to hold a public hearing in Farmington area close to Roser Joint Ventures development area. So please inform me in the future if that is a good possibility. If not, give me the reasons why. But I feel that we have a certain amount of authority to resolve this case with all the parties involved in one place at one time. That's just my thought. Thank you, Mr. Chairman.
Thank you, Commissioner Vicente Aguilar. Well,
Mr. Chairman, can I respond to that?
sure, Russell.
Yes, Commissioner Vicente Aguilar, that is the path we're on. There was a public hearing held before Ashley Shanauer, and a transfer agreement was approved, just as there was for the one system, the smaller system that was still under a boil water advisory. I can't remember the name. Harvest Gold system of AV Water. We are on that track, and in fact, we're at a very advanced stage. In that, as in AV Water, the commission held a hearing before the commission and approved a transfer agreement. And then there was a time for closing. And there were some problems with the closing, but it was done, I believe, within 60 or 90 days. And where we are now is that we've done all those same steps. This has gone exactly as per the AV Water case. And the commission approved the transfer agreement, and now it's just the closing. It's just actually executing the transfer agreement. That is it. The commission has approved the transfer. It just has to actually occur, and the deeds be executed, and the deeds have to be water rights deeds with correct identification of water rights by the Office of State Engineer, and correct identification of newly identified parcels in a new subdivision map from the county. So the commission has done everything as it did in AV Water and gotten to this stage where the closing is hung up. So imagine it going back to AV Water, if after that hearing where the commission approved the transfer agreement, there were some problems that came up in that case, but it did close within, I believe, 60 days. Here, we anticipated it closing within 60 days, and now we're a year and a half out because these agency processes at other agencies are still going. So the commission has done everything it did in AV Water. It's just this is a more complicated, difficult closing. We have done all that. So I just wanted to make that clear.
Russell, have we verified the status of this case with respect to the subdivision map approval by San Juan County and the water rights transfer with the Office of the State Engineer? I think, was that part of our verification?
That is something that what we're waiting for, as per the order approving transfer agreement, is a filing from the parties that says that all of that is going to be completed in an actual transfer with the new identifications of the water rights, et cetera, and the parcels has been effectuated. What we have is filings from the parties that say we're still in those processes. We made some progress. For instance, the parties had to do a survey of the land for the county in order for the county to do the subdivision map. But they say they're still in those processes. And that's where I get to this point where I say, I don't know now. The fact that these two processes are going on so long, I don't know. We're just getting reports from the parties themselves as saying that they're still going on. In fact, this filing that came last week, Sambrito said, well, we will continue to pursue these processes with the county and the Office of State Engineer. And so I don't know why those are taking so particularly long. I don't know if those agencies are waiting for something from the parties, as they were at the beginning. As you will recall, there was a significant delay by the parties with regard to starting those processes. They didn't start the processes until the commission imposed ongoing fines. But at this point, there may be some delay that really is due to the agencies, or a backlog or something like that, which is what is claimed by the parties. And that's something staff can look into as well. But we do have information, but it's just from the parties' filings.
Well, I guess what I've been hearing is that we need additional information. We need a verification in terms of what the status is in the water rights transfer, in San Juan County's approval of the subdivision map. I'd like to, maybe get a description as to the status of the water system from NMED, from their perspective, because right now, if you look at the accumulated fines, that could exceed the appropriation. And so I, in good conscience, couldn't support continuing the accrual of fines because we want more information. So we can either table this issue or amend the order and suspend the fines pending the gathering of additional information regarding the status of the subdivision map, the water rights transfer, and getting NMED's perspective on the status of the water system. So we can get a better perspective on the overall timeline, because this delay could be affecting people that are being serviced by this water system. And so I feel like we need to take the blinders off and incorporate or consider NMED's perspective in this whole situation. So I would recommend we amend the order, and that would be in the decretal paragraph B, to suspend fines, pending the gathering of additional information, and we can outline that. Or we can table this, but if we table it, the fines are going to continue, right? But I think we do need to take action on the second joint motion, correct, Russell?
Actually, the second joint motion, which was one that was filed a month or two ago, has been mooted because it was a motion to extend the deadline for the transfer, and that extended deadline has already come and passed. So my order already states that that's simply mooted, and the commission wouldn't rule upon a moot motion. What was filed last week was these filings showing that the quitclaim deeds had been recorded, and my advice to the commission is that that didn't accomplish anything, because those processes of the Office of State Engineer and the county still need to happen. The thing about the fines, Mr. Chairman, I agree. The fines were effective. They were effective in motivating the parties to actually begin the processes with the Office of State Engineer and San Juan County. So they certainly were needed at one point. But like I said, I don't know that they're needed now, and there's such a high amount. Now, the commission can always decide later, can keep them accruing as pressure upon the parties, to the extent the parties may not be acting diligently, because like I said, they have a history of not acting diligently, and the penalties have a history of working with these parties, of actually motivating them. But the commission could always decide later, based on an assessment of what amount of the delay is due to the agencies and what amount of the delay is due to the parties, that the parties, might not need to be on the hook for this entire amount. But the idea was, this has worked in putting pressure on the parties.
Mr. Chair?
But I don't know how much pressure is needed now. I don't know if they may be acting diligently now, and it may just be the agencies that are taking a long time.
Commissioner
Chair.
Fisher, do you have a proposal for us?
Mr. Chair, I was going to make a proposal.
Yes, please proceed.
And that would be, when you say suspend fines, I'm not quite sure what that means. But for me, what would make sense is to say, freeze the fine at what it is accumulated to be to date. Do not let it continue to accrue. I would hope that whatever actions we take, that over time we can pull in funds that obviate the need for fines, because those are inevitably going to cost the customers of the water system. But that if we just say freeze the fines where they are now, and then do our research and to be continued, to me that feels like a reasonable interim resolution as we move forward getting this other information.
Okay, so you're proposing a motion to approve the proposed order with an amendment to suspend the accrual of fines,
Of additional fines,
of
correct?
additional fines. Okay, is that a motion, Commissioner Fishman?
That is a motion.
Okay,
Okay.
we have a motion on the floor.
Second,
Vice Chair Hall, second to that motion. Any discussion on the motion? Judy, roll call vote.
Yes. Commissioner Maestas,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
aye.
Commissioner Byrd.
Aye.
The motion passes 5-0.
And Mr. Chair,
Yes, Commissioner Fishman.
just one final comment. Russell, really look forward to looking at this bigger picture and seeing what kind of solutions the staff and the environmental department can come up with. I know legislation can be tough, but I think this is one that would get a lot of support from all sides if our agency and theirs and the environmental department can put together kind of a straightforward proposal. And I think it'd be a great service to rural water systems in particular throughout the state. So really appreciate your following up on those issues, Russell.
Mr. Chair.
Yes, no problem.
Yes, Vice Chair Hall.
So just in connection with that, I was scrolling through Article 3 and looking at the Sanitary Projects Act and various other provisions. And there's actually quite a number of legislative measures in place already that address how to handle rural cooperatives in ways that can help them if they're having problems, including being acquired by municipalities or a combination of municipality and county entities. So I think the very first thing we should do is a lot more comprehensive research into what other entities already are empowered to deal with this type of problem before we start proposing more legislation.
Thank you, Vice Chair Hall. Also, Russell, I'd like to maybe work with you on the bench requests. And we need to make sure that we consider this Sanitary Projects Act, in the record, because I know that when we deal on these cases, we can't consider new information unless everyone has it and is aware of it. So if we can do that. Commissioner
Yes,
Vicente
absolutely.
Aguilar, did you have a comment?
Yes, thank you. Russell, once you have obtained all the information that we have requested, I would like consultation, if you can put it on the agenda and explain to the commissioners what the staff has done, what the other state agencies, what they have submitted as far as resolving this case, and a thorough research like Commissioner Hall indicated. I would like a consultation meeting before we decide how we're going to vote. So, for example, you can put it on the agenda, let us know the update, all the information update, and then the following week we can vote on it. In case we run into problems, we might give you a new direction once we have obtained all the information. That's just my thought on it. Thank you, Russell.
Yes, Commissioner, that makes sense. Given the complexity to have a discussion after the bench requests or responses come in, and I think that does make sense to consider it for taking action.
All right, whoever has that dog barking, please mute your microphone. Okay, let's go ahead and move on to item number 6 in the case of 20-158-UT in the matter of commission rulemaking You're out of order. In the matter of commission rulemaking regarding NMPRC Rule 17.9.572 NMAC, renewable energy for electric utilities, and we will be considering a potential order issuing a notice of proposed rulemaking. Judy Amer, take it away.
Yes, I have now tried to sequester myself away from the dog bark. I apologize. We have a visitor dog. It's not my dog, but anyway. That being said, this matter comes before you today upon the commission's own motion to amend Rule 17.9.572, entitled Renewable Energy for Electric Utilities. This case has a long history. I'll get to the bottom line first, and then I can go through the background. The proposed order would issue a notice of proposed rulemaking to amend the rule 17.9.572. It attaches a red line in a clean version of the proposed rule. It attaches a notice of proposed rulemaking, which shall be provided in accordance with the State Rules Act and shall be published in the New Mexico Register. The initial comments are due on July 15th, 2022, and response comments are due on August 5th, 2022. There's a public hearing on August 11th, 2022. Reply comments are due on August 19th, 2022, and the record would close on September 2nd, 2022. And you may recall, it has been a while, but there were remaining issues after the commission adopted the new Rule 572 pertaining to the Renewable Energy Act and Renewable Portfolio Standards. The commission adopted the new Rule 572 in, it was published in May of 2021. And those amendments related to the amendments made in 2019. And we were trying to get the rule implemented as quickly as possible at that time because the amendments to the law had happened in 2019. And we wanted to get the amended rule in place before the 3 investor-owned utilities filed their renewable portfolio standard cases in 2021 for 2022. So that being said, there were what I would call leftover remaining issues that we left unresolved, and we moved them into this docket in case number 2158. And we've asked for comments. We've had workshops, and the remaining issues that are going to be addressed at this time have to do with the use in the future of the renewable or the RPS rate rider. And in this rule, the commission proposes a gradual phasing out of use of the rate rider. And in the next rate case filed by a utility after 2023, the commission is proposing in this rule to eliminate the rate rider and have all renewable costs either reflected in base rates, if they're capital costs, or run through the fuel clause if they're energy costs from a PPA. And I can, discuss that issue in greater detail, but I want to move on to the next issue that's addressed in this amended rule, which relates to distributed energy that generates renewable energy certificates. So I'm going to use the acronyms DG for distributed generation and REX for renewable energy certificates. And there's been an issue that arose from an EPE case, in case number 19-00099, in which the city of Las Cruces alleged that EPE had erroneously counted RECs from DG customers for purposes of RPS compliance. That issue has remained unresolved, and the proposed rule proposes to resolve that issue by eliminating that use. And PNM does not use count DG RECs for RPS compliance purposes, and the commission finds that it should be consistent throughout the 3 utilities. Again, this is a proposed rule. Finally, in case number 19-296, where the commission actually adopted the rule, as I said last year, in May of 2021, the commission adopted an extensive rule regarding when utilities may apply for and receive financial or other incentives pursuant to section 6216.4. That was codified in 17.9.572.22. SPS immediately appealed the rule, the rules 17.9.572.22 in June of 2021, and several other parties intervened in that appeal. They did not agree with the commission's interpretation of under what circumstances a financial incentive could be granted. Several parties intervened and were granted intervention into that appeal. PNM, WRA, EPE, New Mexico Large Customer Group, and Occidental Petroleum. So that's quite a large appeal. That being said, subsequent, as I said, that was before, I think it was on June 3rd, 2021, that the notice of appeal was filed. Before the briefing was done in that case, the commission in December 8th, 2021, issued an order in 21-00, I believe it's 172. That was SPS's renewable portfolio standard case. And in that case, SPS did request a financial incentive. So the previous appeal that SPS filed was a theoretical appeal, just saying on its face, 572.22, it is in violation of the actual statute. They subsequently appealed the final order in 21-00172, which denied SPS their request for financial incentive for the retirement of excess RECs that had occurred in the past prior to the application. Therefore, after that, SPS filed a notice of appeal on January 3rd, 2022, appealing that final order and requesting that the Court of Appeals, the Supreme Court, consolidate the 2 cases, the 2 appeals, which the court has done, and now briefing will be due on the consolidated appeals in June, and for the PRC response brief is due on beginning of August. So that being said, this proposed rule change would clarify some areas of concern and confusion regarding the financial incentive. And I stand for questions. Oh, one more thing is being amended. In the RCT standard, there's the use of the word annual levelized cost, and that didn't have a definition. And we are now adding a definition of annual levelized cost that was proposed by several utilities. So that may be one of the less contentious issues here. I would say that the other three issues, there will definitely be vigorous arguments on both sides.
Thank you, Judy. Any questions for Judy?
Mr.
All
Chair,
right. Yes, Vice Chair Hall.
I'd make a motion to approve the order.
Okay, we have a motion on the floor by Vice Chair Hall. Do I hear a second?
Second.
Second by Commissioner Vicente Aguilar. Any discussion on the motion? Okay, hearing none. Judy, roll call vote.
Yes. Commissioner Fishman,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Maestas.
Aye.
The motion and order passes 5-0.
Thank you, Judy. And thank you for that, that last action. Okay, we're going to move on to the next agenda item. It's in the matter of case 22-99-UT. In the matter of a commission rulemaking to promulgate amendments to NMPRC Rule 17.1.2 NMAC, applications for new rates and new sections in 17.3.510 NMAC and 17.3.610 NMAC to require annual reporting by electric and gas utilities. Our action will be acting on a potential order issuing a notice of proposed rulemaking. Hans, this is you, buddy.
Thank you. Good morning, Chairman Maestas and Commissioners. This matter comes before the Commission to commence a rulemaking proceeding to consider the adoption of proposed changes regarding reporting requirements by IOUs for compliance with Commission final orders. On April 17th, 2002, the Utility Division staff opened this docket by filing the petition to open a rulemaking docket and for the issuance of a notice of proposed rulemaking. The purpose of the rulemaking is to propose changes to annual reporting by IOUs regarding their compliance or lack thereof to Commission final orders no later than April 30th of each calendar year. This would take the place of compliance reporting information in conjunction with general rate case applications. As you may recall, this change was first suggested by staff to the Commission at the March 23rd, 2002 open meeting. My proposed order then proposes the amended language for adoption and issues the notice of proposed rulemaking, setting deadlines for written comments by June 17th, response comments by July 1st, a public hearing on July 7th, and closure of the record by July 21. So hopefully I can bring this back to you after hearing everyone's comments and responses, probably by end of July, first week in August. So with that, I'll stand for any questions.
Thank you, Hans. Any question for Hans?
Mr. Chair.
Yes, Commissioner Fishman.
Yeah, so just to summarize this as briefly as I can, what this would do is take us from reporting individually against separate rate cases compliance, but consolidating all of that reporting about compliance into one annual report where staff and the Commission can look at everything at once. And that would be streamlining the process and help prevent things from falling through the cracks. Is that what we're trying to achieve here?
That sounds like an accurate nutshell, Commissioner Fishman. And yes, you are correct. Like I said, we are removing, generally this sort of compliance report is attached to the general rate case increase request. We are removing it. We are removing it as a requirement from that and simply making it setting a new date for annual compliance reports of April 30th. So it's no longer required for the general rate application, and it's just required now on an annual basis. So yeah, just really removing it from one section, adding it to another.
Okay, thank you.
Mr. Chair.
Yes, Vice Chair Hall.
Well, I just want to say, I think this is a really good idea. It helps us keep track of compliance matters a lot more regularly. And, there's far less, this, I think, really addresses the risk that is real, that unless there's a rate case, we're really not keeping track of what the utilities compliance is. I mean, if there are reports coming in, they certainly don't get to the attention of our level. So I think this is a very good tool. Then I'll make a motion to approve the order.
Okay, we have a motion by Vice Chair Hall, second by Commissioner Fishman. Any discussion on the motion? I also want to echo what Vice Chair Hall had to say. I've been critical of compliance monitoring, and I think John and his staff know all about that. And if we can use some kind of self-certification and consolidation of self-certification of compliance with the commission's final orders, I think that's a good thing. This is a positive development in our effort to step up on compliance monitoring and enforcement. Let's not forget that word, enforcement. Okay, any other discussion? We have a motion and a second on the floor to approve the potential order issuing the NOPR as presented. Okay, hearing none. Judy, roll call vote, please.
Yes, Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd.
Aye.
The motion passes 5-0.
Thank you, Hans, and thank you, Judy. All right, let's go ahead and move on. I think that concludes our action items on the agenda. So let's move on to communications with Chief of Staff. Wayne, welcome.
And here I am.
Yeah, there you are.
Good morning, Mr. Chairman and members of the commission. Nice to see everybody this morning. You're making record time, I believe, so I don't want to jinx that. I don't have a lot of items to cover. Just want to remind commissioners, I had sent out an email a few days ago about the utility Fortnightly magazine wanting to do a feature story on the commission. We've had some understandably difficulties scheduling those interviews here in New Mexico, but Fortnightly is quite persistent about wanting to do a story on the commission, which I think is good. So they have offered to do remote interviews, which they've done with other commissions as well. The story will still be the same. We'll still get a nice cover feature. But if you could just, when you have a chance, either you or your assistants provide me with some dates when you would be, commissioners will be available for that. It'll take about 30 minutes to do the interview. I would appreciate it. And with that, Mr. Chairman, I don't really have anything else this morning, but as always, happy to discuss any items of import to the commission.
So Wayne, and I want to thank Vice Chair Hall. I think she was the one that approached the editor for Fortnightly. So Vice Chair Hall, thank you for that. I just received the latest issue of Fortnightly, and it shows the Florida Public Utility Commission on the cover. Looks like that. So I hope we can at least gather for the group photo instead of getting photoshopped in. So anyway, thank you for that, Wayne. Any questions for Wayne?
Mr. Chair.
Yes, Vice Chair Hall.
No, I don't necessarily have any questions for him. I just want to say I appreciate Wayne's, being the sort of anchor contact there for this kind of, for setting up the interviews and that sort of thing. And I concur with the idea that it would be nice to have a photo. It just, I think it means something. And particularly now, when this is the last batch of elected commissioners, I think And I feel that we're getting so much accomplished. I think it would be a nice thing to do if we could get together for a photo. And I'll certainly try to make myself available whenever there's time, whenever we pick a time or whenever we're trying to work on a time, I'll try to be very available.
Vice Chair Hall, I appreciate that. Any other comments or questions for Wayne? I have one. I just wanted to commend you, Wayne, for redoubling your efforts in recruiting those open positions in the Commission Advisory Services Group. We have a cadre of very qualified applicants, and Sarah in HR will be sending information out on their short list, but this will give all commissioners an opportunity to look at all applicants that have met minimum quals. And so we're going to have a robust, deliberate process to fill the economist position. I did want to ask, how's it going on the engineering position? I think Sarah has done an exceptional job recruiting for these open positions on LinkedIn. So whatever you're doing is working. Can we expect the same for the engineer position, Wayne?
Mr. Chairman, members of the commission, I concur with the work that Sarah and Renee have done on these recruitments. I think I actually have been pleasantly surprised, as you are, with the response on the technical advisor economist, which is the position you're discussing. I can't say, and it has been a little while since I checked in with Sarah. I'll do that after the meeting and provide that information to the commission. I'm not sure we've had quite as robust of a response on the technical advisor engineer, but we will redouble our efforts there as well.
Okay, and again, I still think that it's precedent setting in that we finally established this group. You, Wayne, made the budget available. It's now institutionalized into this organization's chart, so to speak. And so I'm really pleased about that. In fact, I'd like to see an item on the agenda, perhaps a sub item under communications with commissioners, to hear from the advisory services group members if there are any questions. So really, I think to make it more efficient, maybe we can get a weekly report from the advisory services group members, just a summary of what they're doing and what they're going to do, just for the purposes of the entire commission. And then if the commission has any questions for advisory group members, they can ask them at the meeting, but no formal or mandatory presentation at our weekly meetings. So I'd like to see that going forward. Okay, anything else for Wayne? Anything at all?
Mr. Chairman.
Yes, Commissioner Vicente Aguilar.
Yes, I would like for Wayne to explain to us what the process is with the interviews. I know that Renee Kepler shared all the candidates' resumes, but what is the next step?
Mr. Chairman, members of the commission, and Commissioner Vicente Aguilar, thank you for that question. I don't remember the total number of applicants we received for the technical advisor economist, which is the one that the chair is again discussing. We've had the HR, in particular, Sarah, has taken a look, has gone through all of the applications that we have received. And she's created a spreadsheet with those who have who meet the minimum qualifications of the job announcement for the position. We are going to provide that spreadsheet along with all of the resumes for those individuals who have met the minimum qualifications to all of the commissioners. So all of the commissioners will have the same information in terms of who we believe has met the minimum qualifications. At that time, it will be up to the commission to determine how it wants to proceed with interviews. And once the commission collectively has made that determination, we will get those interviews scheduled. I'm hoping, and I believe it's the chairman's hope as well, that we could begin that as soon as those interviews as soon as next week, if the commission is able to give staff the feedback we need to get those scheduled.
Thank you very much, Wayne. Yes, I've been searching for the right process, and I'm glad Sarah is stepping in to guide us and to give us a short list. And it's really important, Wayne, that I hear from the other commissioners what their questions are, which direction they are going with this technical assistant position. And that's the way we've done it before. We hear other commissioners' questions. That way there's no suspicion that one commissioner is overreaching, through the process. So I'm glad you're making this transparency, and I appreciate it. Thank you.
Thank you, Commissioner Vicente Aguilar. I guess, Wayne, maybe I had one more thing. I was going to bring it up under communications with General Counsel, but we're a bit shorthanded in General Counsel, and I know that the staff that are there have been really working their tails off to get orders out in time, and I don't want our staff to burn out, and so the issue of overtime was raised, and I don't know what the existing policy is. If General Counsel staff are expected to work beyond 40 hours a week without overtime compensation, but certainly in light of the current situation in which we are short-staffed, is there any opportunity to set aside overtime in the budget, for General Counsel, or really any part of the advisory side of the org chart?
Mr. Chairman and the members of the commission, that's a good question. I'm not sure. The current OGC staff, I believe, are all classified employees. So if you could give me a few days, and I will report back to you on this next week in terms of what they are eligible for, either in terms of overtime or compensatory time. My assumption is, but I know what happens when you assume, but my assumption is they are eligible for compensatory time. But let me confirm that, and I'll get back to you.
Okay, thank you, Wayne. All right, anything else for Wayne? Thank you, Wayne. Appreciate it.
Chairman.
Yes, Commissioner Vicente Aguilar.
Yes, I'm glad you asked that question about General Counsel. I would like to ask our Chief of Staff to meet with the General Counsel staff and just to give us an update. Are they overloaded with work? We need to get a sense. I know that the past few weeks, there's been no communication from the General Counsel's office when once we get to their agenda item. But just because we are handling complicated cases, I just like to get a feedback, an overall tone of where things are in General Counsel. I haven't received that yet. So, Chief of Staff, if you don't mind, if you can meet with them and give us an update. Thank you.
Mr. Chairman, I'm happy to do that. I'll just, and I'll include that in my report next week, of course, but I will say this, as much as we've been prioritizing the hiring of the technical advisors for the commission, I have been prioritizing making sure that OGC has the resources it needs, particularly with some of the challenges that it's faced over that we're all aware of over the last 3 to 6 months. And I hope you will be pleasantly surprised at the efforts that we've made. Some of them will take some time, but they include creating additional attorney positions for OGC that didn't exist before, taking positions in the agency as we've done in other areas that have been vacant for significant periods of time that we're not filling. And instead of letting those positions sit vacant, reclassifying them to attorney positions in the office of OGC. So anyway, Mr. Chairman, I think that it is a very timely discussion to have, and I'll report more fully next week.
Okay, thank you, Wayne. All right, let's move on to communications with General Counsel. Is that you, Judy, or Russell?
Yes, I don't have any communications, and no one else said they did. And we would be happy to meet with Wayne at any time he would like us to. Tomorrow at 2:00 we're meeting, and we could meet with you then if you'd like to, Wayne. Otherwise, another time.
Okay, thanks, Judy. Any questions for Judy? Judy, I had one. We were getting routinely kind of a look ahead schedule of cases. And perhaps you guys use that internally to OGC, but can you maybe share the next look ahead?
Yes, we can have that on the agenda next week. We can update it. Whatever we've provided you previously.
Okay. Well, that's all I had for OGC. Anyone else?
Mr. Chair,
Vice Chair Hall. Yeah.
oh, just to follow up on that, I'm not sure I understand Judy's answer. I thought that was a sheet that they would just provide us with expected cases for some period of time going forward.
Yes,
but I haven't seen it for a long time.
That's what I mean. I believe we would update our whatever we previously sent you.
Oh, I see.
Because
So
sometimes things that we had, sometimes those matters are still hanging around. Sometimes they've evolved into appeals at the Supreme Court. And sometimes now there's new things. So yes, we would provide the same type of list, and it would be updated and added to.
okay, great. So I thought you said something about putting it on the agenda, and I don't know if it needs to be an agenda item. We're talking about it right now. Did I misunderstand you?
I can put it on the agenda if that's what the commissioners would like.
I'm not asking for it. I thought you were suggesting doing that, and I didn't understand why. I thought it was just a practice that we have that we need to keep up. That's all. I don't think we need to put it on the agenda.
Okay, well then it seems like we'll be creating a new list like we did in December for the end of the year items, and we'll create a new list that is similar, but we'll have different cases on it, and we'll circulate it to all the commissioners. And if anybody wants to talk to us about anything individually, we can do that.
Okay.
Vice Chair Hall, anything else?
No, not on that point.
Okay. I guess I had one more thing. Judy, we had talked about what was needed to initiate the process of a notice of proposed rulemaking for RPS compliance by rural electric co-ops. And I think it's timely because we've really formally engaged in discussions with Tri-State in looking at their most recent energy resource plan. We've been assured, and I'm comfortable that the RPS requirements they're actually ahead of schedule in meeting those milestones. But you had discussed the potential need for, I think, utility division staff to file a petition to initiate the NOPR on RPS compliance by co-ops. What's the status of that?
I can't answer that question. I would like utility division to respond to that. And yes, that would be the way to initiate it. Utility division staff, in conjunction with their lawyers, would file a petition to amend the rule 17.9.5 and 72 and add a section pertaining to rural electric co-ops. And attached to the petition would be a proposed rule as a starting point, because we don't have a rule now at all relating to rural electric cooperatives and meeting RPS standards.
And I bring that up because again, I mentioned the tri-state issue and the communications that we've had with them, which is very positive. But we've also discussed particularly the 80% RPS and how different it is for rural electric co-ops versus investor-owned utilities. In that the 80% RPS for rural electric co-ops is explicit in saying that it's the 100%. I believe it. The 100% compliance, 100% renewable energy RPS for co-ops is explicit in requiring that it includes 80% renewable energy, whereas with the IOUs, it's not clear. It just says that all resources should be 100% carbon free by 2045. So I don't know. We're not legislators. We can't really change the ETA, but I think that's a noticeable difference in the 100% RPS for co-ops relative to IOUs. So, John, do you mind coming forward just to maybe say a few words on that issue? I realize we're kind of at capacity. We have a lot of rulemakings, a lot of balls in the air, and but I feel strongly for us to maybe try and shoehorn that rulemaking into kind of our final plan for the remainder of the calendar year. So has your division talked about that, John?
Yeah, Mr. Chair.
Can you guys initiate a petition so we can get this started?
Yeah, Mr. Chair and Commissioners, we have talked about it. It's on our to-do list. We talked about it amongst the bureau chiefs, and we also have an attorney in the legal division that's been assigned to this task. So we expect to do this in the near term. And at this point, I would guess it will be probably sometime in July, but maybe early August. I've forgotten exactly the timeline we had talked about, but yes, it's definitely on our list. And having an attorney assigned to it is very helpful. It's the same employer who's sitting here, worked on the compliance NOPR that was just approved today. So it is moving forward, Mr. Chair.
Thank you, John. Appreciate that. All right, anything else? Any other questions for General Counsel? All right, let's move on to communications with commissioners.
Mr. Chair?
Yes, Vice Chair Hall.
I have one thing. I had asked Wayne to distribute to commissioners, and he did several days ago, a link to an online seminar on advanced rate making that's endorsed by NARIC, and it can be used to complete our statutorily required educational credits. And that seminar is going to be held Monday, May 23rd through Wednesday, right after noon at 12:30 on May 25th, online. May 25th is a Wednesday, and so that's when we would ordinarily, that's when we have our meetings. So I was wondering if we could possibly move that open meeting scheduled for May 25th to the next day on May 26th. So whoever wants to take that seminar wouldn't have to skip the last day. I'm planning on taking it. I don't know if other commissioners are. I thought maybe one other commissioner was that I'm aware of, but it's definitely something that I feel we need to do to get the credit. So I'd just like to throw that question out. Is there any opposition to moving our May 25th open meeting to May 26th?
No opposition for me. In fact, I looked at the course, and I'm planning on it. So I don't know, any other commissioners, you okay to move the April 25th meeting? Okay.
I'm planning to be there as well. It's just so folks know.
Okay. If there's no objections, then let's move forward with rescheduling the May 25th meeting for. Well, does the course end on May 25th? I don't recall. Vice Chair Hall, do you? Okay.
It ends at 12:30 on May 25th. I mean, I suppose we could have our open meeting in the afternoon, but And I wouldn't be opposed to that either if we need to have it on a Wednesday, but I leave that up to other people have an opinion, a strong opinion either way. I don't. I could, it would make a long day for us, but so what? We've had long days. So yeah, I'd be open to having it on Wednesday afternoon or the following Thursday morning.
Well, I prefer the 26th.
Yeah. We're fresher in the morning. That's for sure.
Commissioner
Chairman.
Vicente Aguilar.
Yes, there was a request from General Counsel's office to have a hearing on the transportation revocation for May the 25th. And transportation staff, they had to provide a notice 30 days in advance. So I believe that we have approved the revocation hearing for May the 25th.
What time?
Is that true?
I think General Counsel's office would have more updated information.
Yeah.
Judy?
We said that the hearing would be on May 25th. And we didn't have a specific time. It said it would be at the open meeting. So if we had the open meeting in the afternoon, that would be fine.
I see. Okay.
So what I'm hearing is maybe May 25th in the afternoon would be best to accommodate the hearing.
Mhm.
We did say that the hearing would be at 9:30. I'm not sure whether we can, so at least when OGC does their notices, they say that the time may be changed. So to check, I'm not sure if Transportation Division includes that language.
Is there a way to look it up real quick and see?
Or I could, can we talk about it next week and I can do some research?
I guess so.
Okay, that's fine.
Yeah.
All right, anything else from commissioners? Any communications? I just have an announcement. Tomorrow, we are having a pre-rulemaking stakeholder engagement workshop on transportation electrification. It's going to be facilitated by GridWorks. I think I've mentioned in the past that GridWorks is directly assisting the Public Regulation Commission in several efforts. But with respect to transportation electrification, they're going to do two things. One is facilitate this pre-rulemaking workshop, and they're also going to plan and facilitate a transportation electrification summit to get the dialogue kicked off. And the main intent of the summit is to basically kind of prime the pump in beginning a statewide discussion on transportation electrification to ensure that the statewide effort to come up with a transportation electrification infrastructure plan as directed by the feds, which is due on August 1st, we want to make sure that statewide plan considers all the approved transportation electrification plans that we adjudicated by each and every investor-owned utility. So I'm inviting all the commissioners to participate tomorrow in the pre-rulemaking workshop. It's going to start at 9 a.m. I will be kicking it off along with Secretary Probst with Energy and Minerals. So this is very exciting stuff. And I invite all commissioners to attend.
Mr. Chair.
Yes, Vice Chair.
Thank you for that information. Is that intended to go all day or half a day or how long? Do you know?
Well, it's scheduled to start at 9 and it ends at 12:30 p.m. So just right in the middle of the lunch hour.
And the summit, do you have a date for that?
I do. Christopher Hall, he is zooming in. It's in June, but I don't have the date handy.
Mr.
Here.
Chairman, Madam Vice Chair, it should be scheduled for June 9th.
June 9th.
And is that all day and where is it located? Do we have that worked out?
I think it's going to be a Zoom conference. Mary Jane Parks, are you on? She might be
I don't see her.
doing the meeting through YouTube. Anyway, we'll get you more information on the
Okay.
summit, the next meeting.
Right. This is very interesting. I'm glad to hear this is moving forward. Thank you very much.
And then Christopher Hall, if we haven't already, if you can send the GridWorks agenda on tomorrow's workshop, on the pre-rulemaking workshop, send it to all the commissioners.
Yes, sir, Mr. Chairman, will do.
All right, thank you, Christopher. All right. Anything else? Any other communications with commissioners? All right, hearing none. It's 11:26. Oh my God, you guys don't know what to do with yourselves, but
Oh, yes.
anyway, we're adjourned. Thank you all.